Maritime arbitration, recent development in Brazil. As widely known, arbitration is the most efficient means of modern alternative dispute resolution. As such, maritime arbitration is deeply rooted in shipping practice through arbitration clauses appearing in contracts or being voluntarily adopted by the parties in other circumstances. It is also a fact that in some countries maritime arbitration has been facing some criticism due to its high cost and/or the time expended for the arbitral award to become final. Even in the countries where these criticisms are made, they have been adjusted to reflect a decrease to a certain degree in the efficiency of arbitration as a means of dispute resolution, however, never enough to make it lose its precedence over court litigation in most, if not all, jurisdictions as a more adequate tool to achieve a just solution for controversies. Until the late 90s and early years of the new century, Brazil was apart from the development of arbitration then taking place in the rest of the world. But in 1996, the Brazilian Congress enacted Law Number 9, which removed the legal obstacle to effectiveness of arbitration in Brazil, thus bringing Brazilian law in line with the most modern legislation in this area. Further, in 2002, Brazil ratified the 1985 New York Convention, therefore definitely joining the modern legal regime on arbitration. In an unexpected manner, Brazilian market and legal practice reacted very rapidly and strongly to the legal innovation. It took only 5 years for Brazilian arbitration to grow exponentially to such an extent to rank in the fourth position of ICC, International Court of Arbitration Statistics. Ever since, Brazil has held this position, coming after only USA or Canada, Germany, and France. On top of that, 188 arbitrations were filed in 2013 with the other six major Brazilian arbitration entities other than ICC Brazilian branch and the amount at dispute in these six entities. Brazilian arbitration is now widespread. Its main areas are corporate, infrastructure, and energy dispute. The central reason for this extraordinary development lies certainly in overwhelming workload that Brazilian judiciary has been facing, especially since the enactment of new constitution in 1988. Although this constitution has greatly expanded the federal court system and some states have done the same with state system, the democratic access guaranteed to all under the new constitutional regime combined with the increasing growth of civil society segment have channeled to all branches of the judiciary a quantity of work that the system has in the general been unable to cope with. Litigation increased and it continues to grow on a yearly basis. In 2013, around 95 million cases were in progress before Brazilian judiciary, a growth of 3.3% in relation to 2012. The congestion percentage rose from 70% to 70.9%. Notwithstanding this exceptional development of Brazilian arbitration, in general, maritime arbitration strangely didn't follow the trend of all other areas. Although arbitration solution is highly familiar to shipping activity, almost all standard forms incorporating arbitration clauses, Brazilian shipping didn't develop. At first, a national arbitral culture and hence Brazilian parties in the shipping sector didn't revert their dispute to local arbitration. But paradoxically, at the same time Brazilian parties kept the long tradition of often referring matters to foreign arbitration. The negative consequences were obvious. Whenever foreign arbitration didn't apply, Brazilian parties resigned themselves to letting local dispute to proceed to the court, where litigation, in average, can easily take 8 or more years to come to an end. Another negative alternative became quite a common practice, the amicable settlement by the defending party and or their insurer even when the party's right is good with positive prospect of defense. Particularly, P&I clubs and other foreign insurers choose this otherwise unjustifiable in settlement avenue as the lesser of two evils due to the punishing rate of Brazilian monetary correction and legal interest, much higher than any rate of return of US and EC investment. However, this landscape is now changing. Last year, Brazilian Maritime Law Association Chamber of Arbitration, the only specialized entity in Brazil for maritime arbitration, received arbitration application of two cases, which when added to one pre-existing cases with still in progress, totaled three cases simultaneously processed, a number never achieved before. Also, in 2014, the Chamber of Arbitration of Getulio Vargas Foundation in Rio de Janeiro, a very reputable academic institution, which amongst other things is also devoted to arbitration, institute for proceeding on maritime dispute. So, in all, at least 7 maritime arbitration were brought before arbitral entities in Rio de Janeiro. Also, still shy in absolute number, 2014 definitely marked a remarkable beginning for Brazilian maritime arbitration. In last January 2015, another initiative showed the intensity with which maritime arbitration is now becoming a part of the overall picture of Brazilian arbitration. Several companies, including Transporto, the greatest Brazilian ship owner, and Petrobras shipping branch, local law firm, and marine adjuster, have joined together to found the second specialized Brazilian arbitration chamber for maritime dispute, reenacting the same format of the well-succeeded experience of Singapore International Arbitration Center. The newly incorporated Brazilian Center of Maritime Arbitration is an arbitral entity designed to be managed by the very potential user of arbitration service. Law Office Carbone has taken a leading role in this unprecedented development of Brazilian maritime arbitration. One of its partners, Luiz Felipe Galante, in his capacity as legal director of the Brazilian Maritime Law Association, is in charge of administering the arbitration services of the three cases now in progress in that association. In addition, the association under the presidency of Law Office Carbone's head partner, Arthur Carbone, is enacting an entirely new set of arbitration rules and code of ethics so as to keep pace with the most recent legal development of Brazilian arbitration. In other four maritime cases before the Arbitration Chamber of Getulio Vargas Foundation, Luiz Felipe Galante is acting as a co-arbitrator in three of them and as president of the arbitral tribunal in the remaining one. Thank you.